Good morning and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Thulo Royan. It was a dramatic day once again in the Pretoria High Court, and the focus is still on Kelly Khumalo. What unfolded yesterday is or centered around the summary of substantial facts which were read to the court at the beginning of this trial, together with the indictment or the charge sheet. But I will, for purposes of this video, focus just on the summary of substantial facts. You see, when this trial started, the prosecutor, Baloyi, read the summary of substantial facts into the record. And that summary of substantial facts said nothing about Kelly Khumalo. And that is very important. Now, the people in the dock, the accused persons, never had anything about Kelly Khumalo, let alone her being a mastermind in the commission of this crime. So they were read the charges and the summary of substantial facts that outlined how intruders burst into the Khumalo house and killed MEYIWA, and also in the process robbed a cell phone. Apparently that cell phone was robbed from Kelly Khumalo. That is the summary of substantial facts that Baloyi presented to the Pretoria High Court. That being the case, as the case unfolded, and under cross-examination by the late advocate Thulani Mgomezulu, that is why it first came up, Gininda for the first time shocked that courtroom, including Baloyi, to say that Kelly Khumalo was the mastermind behind this crime. In other words, that Kelly Khumalo had commissioned the crime and had even paid the people who executed the crime, allegedly the 5 people facing trial in the Pretoria High Court. Now, that disclosure came as a shock, like I've just said, to everyone, because it did not form part of the summary of substantial facts. And if this was the trajectory or the path along which the prosecution wanted to conduct its case, it should have rightly indicated at the beginning of the trial, when Baloyi was reading that summary of substantial facts, to have included Kelly Khumalo. You see, the summary of substantial facts is not just a summary that is read to the court. It is read to the court and forms part of the record. Not only does it form part of the record, but it also gives an indication, just like the charges, to the accused persons what they are supposed to have done on the day that MEYIWA was killed back in 2014. Now, the issue that Mnisi was pursuing here is that, the non-disclosure, or is that non-disclosure by the prosecution in their summary of facts at the beginning of the trial, that Khumalo was in fact not only supposed to be charged with the accused persons that we see before the Pretoria High Court, but that she was in fact the mastermind. In other words, the chief perpetrator of this crime. If anybody is guilty in this matter or has to be held accountable for the commission of this crime, then it is the mastermind. Now, when Advocate Mnisi pushed for this, Baloyi was at pains to argue that the summary of substantial facts, or the summary of the prosecution rather, is not bound or confined to the summary of substantial facts. And that is where it became heated. There were heated exchanges between Baloyi and Advocate Mnisi, because Advocate Mnisi explained to the court that the prosecution is bound by the summary of facts. They cannot deviate substantially from the summary of facts such that, they bring something else to the court outside the summary of facts. Much as the law says they are not bound they're not bound to the summary of facts, Mnisi went on to say that they are not bound in respect of, minor details like time and so on when the crime was committed. But insofar as the substance of the charges are concerned, the prosecution is bound by that summary of facts. In other words, let me just give you an example. The prosecution cannot present a summary of facts about the commission of a sexual offense and then come up with evidence about the commission of murder. That is simply never allowed. And much as they are not bound by it, they are not bound by the summary of substantial facts in respect of finer details, a few minor details. But here we are seeing the prosecution move away completely from that summary of facts in a very profound and substantial manner. Because, like I've indicated in my opener, the summary of facts presented to the court never said anything about Khumalo being the mastermind. It comes as a complete surprise. And it comes by way of cross-examination. You see, this disclosure by Gininda that Khumalo was the mastermind was never going to get disclosed. It only get disclosed for the first time when the late Advocate Tulani Mngomezulu cross-examined Gininda. In other words, it was not something that, Gininda was going to disclose to that court in his evidence in chief. So what we are seeing here is the prosecution deviating or moving away or distancing itself, from its own summary of substantial facts by making now this disclosure that Khumalo was the mastermind. And you see, this is a gross irregularity, because when people come before a court and they are charged, not only are they read the charges, But in that summary of facts, they are also told, in summary form, what is supposed to have happened and how it was supposed to have been done. Now, that summary of substantial facts leaves out a very key and pivotal individual. If we go by the testimony of Gininda, that Khumalo was the mastermind. That is left out in the summary of substantial facts. So that is where the battle was. It came very heated at time because there was a time when Baloyi, rose up to object that, the decision whether or not to prosecute lies with the prosecution, and that Gininda is not supposed to know anything about that, and that Gininda had answered that question. And Advocate Mnisi rose to say, maybe my learned colleague is listening to some other evidence, not the evidence that is being led before this court. It triggered a very angry response from Baloyi, who told the court that, Advocate Mnisi is being acerbic, he's being contemptuous by use of that kind of language to say, he is listening to some other language, to some other evidence other than what is being tendered before this court. But in reply, Mnisi was adamant and stuck his ground and said, no, there's nothing acerbic about what I'm saying, because this is evidence that has been led before this court, and if my learned friend, says it was never tendered, then he must be listening to some other evidence, not what is transpiring before the court. Judge Ratamukwate then, intervened to say that, among other things, he said, he is aware that there are other lawyers. He did not name them. He said there are other lawyers in this trial who just don't care about the decorum of that court. So that is how it went, clearly indicating that, Gininda and Baloyi are at odds. They are at odds because they have failed to make a material disclosure, a very important disclosure. And like I indicated earlier on, that is a gross irregularity. So this morning, Mnisi is still on Gininda, and it will unfold and unfold, and Mnisi is digging deeper and deeper in spite of all the odds that he's facing. So let us see what happens this morning, and in a later edition, a midday edition of the Daily Fix, I'll be giving you an update of what is going to transpire this morning. Having said that, let me thank you for watching this video, and let me also thank you for watching all the other videos in the past. Please like and share these videos and kindly subscribe. Thank you very much.